So after the first three consolidated cases, there'll be a brief recess while we reconvene the panel. The first three consolidated cases for argument and briefing are State of Florida versus Oppenheimer, State of Florida versus Pedagine, and State of Florida versus Klutz. Is the appellant ready to proceed?
Yes, sir.
You may. And I do understand the appellees have requested, sir, rebuttal that will come out of the 30 minutes time. You have 30 minutes for your side. How you apportion that is up to you. You may proceed.
I have to put some stuff back. Okay. May it please the court, Virginia Harris on behalf of the state of Florida. I suppose I would like to allot 20 minutes for the state appeal with 10 minutes for me speaking at first and 10 minutes for rebuttal, and then the final 10 minutes for the one in which I am the appellee.
All right.
And in this case, Your Honor, essentially, we have an order from the trial judge that doesn't make sense unless, he erred as a matter of law. He essentially found conduct sufficient for the misdemeanor hazing, but then found it insufficient for the felony hazing. The trial court admits in its order that the only difference between the two statutes is whether harm occurred or whether there was a substantial risk that harm occurred. And so it doesn't make sense that the conduct can be sufficient for the misdemeanor and not for the felony unless you look at the language in his order that indicates that he erred. He indicates that despite the fact that the legislature said consent is not a defense, that basically he says the victim was a superseding cause because his decision as an adult to drink alcoholic beverages was the reason that he died.
Well, is it not possible to read that as the trial court finding no force consumption of alcohol, and therefore without force it's not hazing?
No, because he actually says, despite the fact that the legislature says consent is not a defense, this is a difficult concept to apply in this case, and then says his decision as an adult, and then indicates even if they created a scenario. And our position, I'll get into this next, is that the state does not have to allege force consumption. But
would pressure, or I'm sorry to jump you ahead, but would pressure or coercion be required at least?
Yes. The state's main theory seemed to be pressure or coercion because, as I'm sure you know, the pledges were mostly all under the age of 21. In fact, some of the brothers were under the age of 21 too, including Mr. Coffey's big brother.
Just to crystallize the argument, if the drinking age in Florida were 18, there would be no crime here of hazing, is that right?
I'm not sure that's true, and what I'm about to say is answering this question as well. The statute, when it's defining what hazing is, says it includes but is not limited to. This statute wasn't designed to say these things are the only things that can be hazing.
But I mean, the state's theory here has to be that under the statute, I think,
yes,
that the pledges were pressured into violating state law by drinking under the age of 21.
right, yes, that
There was
is.
no other activity that would have been encompassed.
No, I agree, and that is our theory. I'm just, had they not been under 21, and you don't have to decide this, I think that under the statute that could be prosecuted anyway if you pressured somebody to drink to that extent. But going into what that statute actually says, because there's a lot of discussion about force here, is not only does it say hazing includes but is not limited to pressuring or coercing the student into violating state or federal law, it then says, comma, any brutality of a physical nature such as, and in its list says, forced consumption of any food, liquor, drug, or other substance. So when it's talking about force there, it's actually kind of saying this is an example of brutality of a physical nature, and that is an example of hazing.
And
It
the
is-
state's case isn't that this is a physical brutality
No,
case.
absolutely
Or
not.
the third one, extreme mental stress case, it's not a case of that. So this is just a case
This is,
of
it's
pressuring
pure,
to violate law.
Yeah, pure pressure to violate the law. And this
Well,
situation.
where is there evidence, though, that any of these three defendants exerted pressure on, as opposed to a general, dating back from Animal House, Revenge of the Nerds, societal, and I don't mean to be, to joke about it because it's serious, but, obviously there's a lot of expectation out there for college students underage to drink, and certainly for fraternity members underage to drink. But where is there pressure beyond just a general kind of societal expectation that, there's certainly not, pledge, you finish that bottle or you're out, right? I mean, it's
Not
much more
explicitly.
subtle than that at best.
Right. Well, essentially, now I acknowledge that the state did say, the statute says act or scenario. So the state was arguing that these defendants could be liable directly for creating a scenario, but the state indicates in the hearing that its primary theory is principle theory. And so essentially it would be similar to the judge's findings that at this Big Brother event, there is a tradition that's been going on for years of them drinking the family bottle and excess drinking and getting hammered.
Well, and the probable cause statement said finishing
Right.
the bottle. The statement of particulars was a little more vague and said finishing the bottle or drinking to excess.
Right.
So, I mean, just the fact that there was some societal or institutional expectation that they are drinking to excess, that would be hazing under the state's theory.
Well, no, it's that this particular fraternity had a tradition and an expectation of finishing the family bottle and getting hammered. And it's not just that. I mean, there's drinking games and all kinds of things going on there. And that these defendants, it would be Mr. Pettigene, hopefully I'm saying all these names right, who is the president, and Mr. Oppenheimer, who is the chief financial officer or treasurer, and then also Mr. Klutz, who's the warden,
Well,
that
and
they're
if-
all on this.
If one of them said to the big brothers assembled, big brothers, make sure your little brothers polish off their bottles tonight. I mean, I think you got principle there. But for principle, don't you need some act or direction to facilitate the crime?
That's right. And what I'm saying is, first you have to know that a liquor ban was implemented because they already knew that this pledge class had a problem with drinking. But yet they still made the decision to have this Big Brother party, knowing what would happen, and they lifted the liquor ban. And that's essentially the findings of the trial court. And in doing so, they encouraged or assisted what Mr. Ravello did. Mr. Ravello is Mr. Coffey's big brother, who then gave him the big bottle and, went on with this tradition. Had they not approved the party and lifted the liquor ban, then this wouldn't have happened.
How far does the liability go in that regard? Are all brothers or all big brothers potentially responsible for not fixing this culture of drinking?
Well, I mean, it would be dependent on if you look at the statements, everybody says different things about what their big brother said or did. And so it would depend on the circumstances. But if the big brother was, on board with this culture and, assisted with it or acted at their direction, then yes, they would be liable.
And in fact, several were charged, right?
Yes. Of course, Mr. Ravello, a lot of them have pled already. And so I know that, there's been some, and I'll probably talk about this more, discussion about the law being changed, but that doesn't really affect this case because the state proceeded on principle theory. So the law being changed wouldn't affect our ability to charge these. So that's basically the state's theory. And in terms of...
So the charge against the president, who I understand was not at the party, is the act. The statute talks about an act or situation. So the act as to him not being at the party is creating a
Right.
traditional or making decisions, facilitating this traditional party to take place.
Right. They created the scenario, or the state's main theory from reading the record is that they were principals. They encouraged, incited, by their actions of because you have to understand, this isn't just a normal frat party. This is the traditional party, Big Brother party, with the expectation to finish the bottle. And I think it makes it even worse that they knew that this particular pledge class had such a problem that they had to implement a liquor ban. And the fact that they approved this party and that they lifted this liquor ban shows that they had the conscious intent that the hazing occur. And there's some discussion below about, a lot, well, they didn't want Mr. Coffey to die. Well, of course not. We're not suggesting that they did. It's the intent that the hazing occur, especially when you couple it with the fact that two of them, Klutz and Oppenheimer, were actually at the party and did nothing to stop this. But I'll reserve the remainder of my time.
May it please the court, Michael Efferman, on behalf of Mr. Klutz, let me start by giving you the batting order. Mr. Tannenbaum and I are going to divide or take 20 minutes of our 30 minutes, and of that 20 minutes, we'd like to reserve 3 for Sir rebuttal, and then Mr. Turner will have the remaining 10 minutes. And it's my goal to argue for about 8.5 of our 17 and then go to the bullpen for Mr. Tannenbaum. And I'm hoping to focus on the felony count and then also address the misdemeanor count insofar as it relates to the speedy trial claim. Regarding the felony count, I think this issue can be resolved solely by looking at the plain language of the statute. This is a statutory construction case. The legislature has specifically defined acts of hazing, and we know the Florida Supreme Court less than a year ago in the Martin case said that an examination of those elements readily reveals that they are that the legislature has substantially narrowed the scope of criminal liability under the statute. So what does the statute say? It starts with a very general provision dealing with pressuring or coercing someone to violate state or federal law. But then it gives very specific examples, 6 of them from that point forward. The first one involves brutality or beating. That's not this case. The state has acknowledged that. The remaining 5 all begin with the word forced. And in particular, the only one that applies to this case is forced consumption of any food, liquor, or drug. This is a case where the state is alleging that Mr. Coffey died of alcohol poisoning. The legislature has defined what type of hazing activity would apply to someone dying of alcohol poisoning. It's not someone who was drinking and then was told to swim in a lake, like Chad Meredith, or engage in some other activity. This is simply he drank, and he died from drinking too much, alcohol poisoning, and the legislature says in that context, the hazing activity that would be criminal is forced consumption of liquor.
Okay, so I was reading the statute as having 3 prongs: pressure to violate law, brutality, physical brutality, or extreme mental stress. But that division isn't. And that what you're talking about, the forced consumption, forced other things, we're all under this brutality because it says any brutality of a physical nature, such as whipping, etc.
I think brutality is the first conduct that's being described. It doesn't involve some type of forced behavior because you're not forcing someone to have to be beaten. They're being beaten by someone else. But the rest of it goes into forced consumption of alcohol or liquor, forced physical activity that could adversely affect the physical health, forced exclusion from social contact, forced conduct that could result in extreme embarrassment, or forced activity that could adversely affect the mental health or dignity of the students. So our particular example is specifically described by the legislature, forced consumption of alcohol. So in this case...
How does situation fit in here? The state contends that the officers created a situation that endangered. Why is that not correct?
Hazing means any action or situation that recklessly or intentionally endangers the mental health or physical health of the student. But then it goes on to and say hazing includes but is not limited to, and then gives the other specific examples. So whether it's an action or a situation, if it involves dying from alcohol consumption, the legislature has specifically described the only conduct that is illegal. And again, we know the Florida Supreme Court just said this is a limiting statute. The legislature is narrowing those things that can amount to criminal hazing. So, and I think Judge Fitzpatrick said it best in his order, and this is footnote 1 of the order on page 5. If the legislature intended to prevent underage drinking to excess at fraternity events, it could have stated that merely allowing such illegal behavior at a fraternity event is hazing. It has not done so. It's that simple. I mean, we can all be concerned about an incident or a situation or the actions in this case that involve Big Brother reveal night, where there was a tradition that the Big Brother would give.
Well, couldn't the legislature have had two things in mind? One is pressuring someone to violate the law, which would include
Robbing a bank.
Yes, it would include robbing the bank, but also pressuring somebody underage to drink. But also forced consumption that wouldn't have this age thing going on, that you could force somebody who's 21, 22 to consume alcohol, and that would constitute hazing, but that wouldn't constitute necessarily a fort or a pressure to violate
So
law.
two answers to that. So directly answering that question, I think the first provision is a very general provision. That's why I gave the robbing a bank. We can come up with any number of situations that would be a violation of state or federal law, that if a active told a pledge they had to do, that would violate that provision. But then the legislature went more very specific when it comes to alcohol consumption. And they said the only activity that amounts to hazing when it's involving alcohol consumption and nothing else, not been swimming in a lake or doing whatever, is forced consumption. So I submit under a basic principle of statutory construction, the very specific statement, forced consumption of liquor would control.
So under your theory, if the fraternity said, we're going to have a great big party and we want all you pledges to bring your 10-year-old brothers. Everybody with a 10-year-old brother, bring them to the party. We're going to give them alcohol. And a 10-year-old drinks a fifth of liquor and dies. Is that not hazing?
If it's not
Under your argument, that's not hazing, right?
It may be manslaughter, it may be some other crime, but hazing in this, again, the legislature could change this, and they could specify that underage drinking in and of itself would
Well,
amount.
isn't that what they said when they said pressure into violating state law?
No, that, again, so the general versus the specific, and my initial assertion is that you have the specific would control, and they've described the type of conduct that is required to prove a crime when it comes to consumption of
So
alcohol,
under your
and it's only
argument,
forced.
Bringing a 5-year-old to the party and giving them a fifth of liquor and they died from alcohol poisoning would not be hazing.
It's correct, but then the other thing is, even alternatively, I would submit that under this statute, the state nevertheless still has to prove, if you're going to go with the first general provision, that it is pressuring or coercing the student into violating the law. The state didn't even allege that in the statement of particulars. The closest they get is the second to last page, where it says, drinking games took place and the pledges were encouraged to illegally drink. And on the continuum of pressure, encouraging someone to do something is less than pressuring or coercing. Coercing, I have the definition of coerce. Coercion means by force or threats. Force itself means by physical power or coercion. Very high up on the continuum of pressure. So if the state is only alleging in this case, and that's all they can allege, and I appreciate their candor. Mr. Campbell came right in and said, we are not going to be able to prove that anyone forced someone to drink. And I know the court knows the facts, but let me just state, because it's very helpful to our client based on the facts of this case. There were people that didn't even go to this party. No repercussions. 2 to 4 didn't even go.
But isn't that a factual argument that's not suitable for a C4 resolution? And that's your argument to the jury. Ladies and gentlemen of the jury, lots of people didn't come to the party. Lots of people didn't drink. My clients aren't guilty. They didn't pressure them. That's a factual argument, isn't it?
I guess I'm saying that in the context that led Mr. Campbell to acknowledge in court that he can't prove forced consumption because there were people that specifically said there was no forced consumption, and he can't even prove pressured or coerced. All he can establish, and this statement of particulars takes the place of, certainly the affidavit's not a charging document, the probable cause affidavit, and it takes the place of even the information. All he can argue is that they were encouraged to drink. That's what he's alleged. Encouraging to drink is insufficient under the statute, and therefore Judge Fitzpatrick was correct when he granted the motion to dismiss, either A, because they failed to allege an essential element, or B, because they failed to comply with the order, not out of some negligence or intentionally not complying. They did file a statement of particulars, but their statement of particulars never told the three defendants what act of hazing occurred in this case.
Judge Thomas's question raises a procedural question in my mind. Was this a C4 motion or just a C motion?
It's a C motion.
It was allowed, apparently untimely, right? I mean, I guess that doesn't matter, but there was no traverse by the state, which you would need to have to a C4.
Correct.
But you don't have to traverse to a C, just a regular C.
Correct. I think a C4 would go, the facts don't amount to a crime. That's not necessarily what's being argued here. I think it's two-part. Number one, there was a motion to dismiss by Mr. Oppenheimer because they failed to allege an essential element of hazing, and they were directed to specify the element of hazing that applied in this case based on the order granting the motion for statement of particulars, and they failed to do so. Alternatively, Mr. Tannenbaum filed a motion on behalf of his client and said, now that they failed to comply with your motion or your order directing statement of particulars, you must dismiss the case. Let me quickly move to the misdemeanor, and I'll let esteemed co-counsel address other questions relating to the felony. I think the misdemeanor is straightforward. There is a single charge here. The clients were arrested in January 17, 2018. The single charge that was filed was a felony. It's not two counts. It's not a count of a felony and a misdemeanor. You look at the January information, there's no question that that's a felony count. It says F3. It says that Mr. Coffey died. Granted, they cited to the wrong statute, and that was something that they had to correct, but that in no way makes this a misdemeanor charge. They wouldn't be in felony court if it was a misdemeanor charge. It was a single count, and it was a felony count. And then after 90 days expired, they said, for various reasons that I'm sure the court is aware, we're going to add a second misdemeanor count. Every prosecutor must be aware that if you're going to arrest someone for one course of conduct, which Mr. Campbell specifically said during the hearing on the motion for statement of particulars, that this information charges all conduct involving all pledges for the entire fall of 2017. If you're going to do that and you ever want to add a misdemeanor, you better put on your calendar 90 days, because after the 91st day, you can't do it. The fact that my client may have been on notice that they could have charged a misdemeanor is completely irrelevant. This is not a notice statute. You must charge within 90 days. And the fact that there may or may not be prejudice is also irrelevant. If you fail to charge within 90 days, the Williams case, it was my case from the 5th DCA, specifically said, if you don't charge the misdemeanor within 90 days and the misdemeanor arises out of the same criminal episode from the felony, that's the end of the case dismissed. I think that the argument is very clear on why speedy trial requires the misdemeanor to be overturned. I'll turn it over to Mr. Tannenbaum. Thank you.
Good morning. My name is Brian Tannenbaum. I represent Anthony Pettigene, who was not at the party. And when we started in this case, we asked a very simple question, and that simple question was, what did our clients do? And the state was very candid and said, well, they created a culture, and there was indoctrination, and that's why Andrew Coffey eventually went to this party and drank too much and died. So we went into the judge and said, we need particulars. We need to know exactly the individual acts that were committed by our clients. My client was the president of the organization, and that's how the probable cause affidavit began. He was the president. He was liable for everything that went on in the fraternity, whether he planned it or not. So we asked, under the hazing statute, because it requires an act. It requires that an individual, to be charged with the crime, do something. What did Anthony Pettigene do to cause Andrew Coffey to die? And the answer was, well, he was the president, and he planned the party. And then what happened was, as we see the relevance of Andrew's law, which was a statute created as a result of my client, is now after all of this, if you're involved in the planning of something, you can be held liable. So it was recognized that just being a corporate officer in a fraternity is not an act that causes a hazing activity.
Is that where we get into the statute's talk of an act or situation, so that to the extent that they are deciding to carry forward this tradition of this particular party, lifting the liquor ban, and some of the other things that are in the record, that this situation was created. This event was going to happen as a result of the president, the executive council deciding this this traditional party's going to happen.
So the traditional party was going to happen. But then when we're looking at a specific statute, so we have different statutes in Florida. We have an open house party statute, which creates misdemeanor liability for someone who's in control of a home and serves alcohol to minors. Hazing was created for a very specific problem, and that was what was going on in the college fraternity system. And what we were seeing was the Animal House situation. Kids were being lined up. They were being told, you better do this. If you don't, you're not going to get in the fraternity. And they were being hazed and they were being brutalized. And so the legislature said, here are the specific things. We're not limiting to this, but we're going to tell you exactly what you can't do. One of the things you can't do is you can't force someone to drink alcohol. Now, under the rules of statutory construction, obviously non-forced drinking would not be hazing. If a fraternity pledge goes to a party and says, I'm going to drink this bottle because I feel like I want to drink this bottle, and then that fraternity pledge dies or is seriously injured, you can't then say, well, somebody else committed an act of hazing, because the statute clearly says that forced consumption of liquor is required. And in this case, as Mr. Ufferman said, Mr. Campbell was very candid to the court. I can't prove that alcohol was shoved down anybody's throat. So we stand here today knowing that there was no forced.
Does this statute prohibit pressuring an underage person, whether they're a pledge or a 15-year-old or a 10-year-old, to drink? Is that outlawed by the statute?
If it's in the scope of a fraternity event, then pressuring someone to drink would be prohibited. But the state still has to allege that that happened. And what's happened in this case is very clear. The state alleged that there was a culture. They haven't alleged that anybody specifically committed an act of hazing, but what they said was there was a fraternity, and there were officers, and there was a party, and Andrew Coffey went and he drank and he died. And Judge Fitzpatrick said, okay, we understand that. You need to tell these defendants exactly what act of hazing they committed that resulted in the death of Andrew Coffey. And he was clear in his order that, dismissing the felony count, that the state has alleged no felony hazing at all. Nothing. And as a result of this case, as I said before, the legislature had to go back and say, well, we've got this defendant here saying he wasn't at the party, and that could be a defense since he wasn't near Andrew Coffey. He didn't give him alcohol. He obviously didn't force him to do anything. So let's expand the statute to say, well, even if you're involved in the planning of some event that results in hazing, you can be held criminally
I think there's
liable.
internal conflict in the order between the ruling on the, and I guess because of your cross appeal that you do, between the ruling on the misdemeanor and what he cited factually, paragraph 15, this Big Brother ceremony, the executive decision to lift the ban, the family drink tradition, all this stuff that he cited as being the reason that the misdemeanor count should go forward, seems like they would apply equally to the felony count.
Well, you're correct. There is a conflict. And Judge Fitzpatrick clearly did two things. He said there's no evidence of felony hazing. But there's all these allegations of misdemeanor hazing that I believe happened. Holding a quarter, chewing bubblegum, all these things that he listed. But in the end, it's not just an act of hazing that matters. The result is what matters. Because there can be an act of hazing that results in nothing. Okay? If the pledges are all told, you need to come to Doak Campbell Stadium and clean this place up or you're not getting in the fraternity. Well, we can't say that could result in a substantial risk of injury or death. That's just...
You're using hazing in the kind of dictionary sense as opposed to the statutory definition.
No, I'm talking about what's required in the hazing statute.
Cleaning up Doak Campbell Stadium or carrying around a quarter doesn't expose anybody to substantial risk.
Right, but it's still, I'm talking about a mandatory action. I'm talking about the fraternity saying as a pledge, in order to get in this organization, you've got to do X. Is that hazing? Well, if it potentially results in substantial risk of injury or death, yes. But just making somebody do something is not an act of hazing, even if it's done in a requirement for them to become a member of a
So
social
what
group.
was the purpose of the reveal party?
It was a party. It was a celebration of the big brothers and the little brothers.
Was it just intended to show the pledges how much the brothers loved them and how much they appreciated them being a part of the fraternity? Or was it intended to make the pledges perform certain actions?
Well, the answer to that question is there's no evidence that these pledges were lined up. Number one,
My
there's
question is, let me try it again.
Okay.
My question is, was this a party intended to just show the love that the brothers had for the pledges? Or was this a party to force the pledges to perform certain actions?
It was not a party to force the pledges.
Just a party to
Just-
celebrate life in general?
And the evidence of that is the fact that there were people that didn't show up and there were people that showed up and didn't drink. There was no allegation.
But that goes to the facts of the case, right?
But this is what Judge
Not to whether or not you dismiss as a matter of law.
But Judge Fitzpatrick said to the state, tell me what happened at that party. Tell me the facts that go to
But
this
he's not
statute.
the jury. Of
course.
The question is, as a matter of law, was there pressure for underage persons to drink?
There's no evidence of that.
What's your answer to that?
There's no evidence of that.
No evidence of any pressure on the pledges to drink?
There's no evidence of any pressure just based on what was alleged by the
Just
state.
Here's a fifth of alcohol, and if you want to drink, you're great. If you don't, that's okay too.
And if there was evidence presented that there was a consequence of either not showing up or not drinking, then I would agree that there was pressure. But none of that was presented. As far as what was put onto the record, these pledges were invited to this party. Some went, some didn't go. Some drank, some didn't drink. And there was no allegation.
What do you think the meaning was of blindfolding them or whatever it was and paddling them and telling them they weren't getting in and all that?
But that didn't happen that night.
Okay.
And I'm out of time.
All right. Thank you.
Thank you.
I'm not sure how much time I have left, but I'll give it my go here.
Well, you've got 30 minutes total. However y'all decide to use it is up to you.
Yes, sir. Stephen Turner for Defendant Oppenheimer. Let me focus briefly, quickly on the fact that the Martin case, which is binding on everyone here and made clear at 259 Southern 2nd at 742 that the specific core hazing prescriptions of the statute must apply to the conduct falling squarely and unambiguously within their ambit. And if you're going to charge that a risk of harm or causation of an act is over intoxication, it's not causing safety problems, we're not running out in the street, none of that is the risk involved here. It's simply over intoxication. And that goes to consumption of alcohol, and that is a specific core prohibition of the statute, and it's not alleged or met in this case.
How do you
That's
read?
it.
How do you read pressure to?
Pressure is
to
a
violate-
general,
hold
excuse
on.
me, Your Honor, yes,
That's all
sir.
right. Pressure to violate state law. How do you read that?
That is not binding here. In fact, Martin specifically said you can have, Martin made a
Martin was a
quote,
void for vagueness challenge
Yes,
based
sir.
on whether it encompassed free speech.
and they said that it may come within the definition, recognizing that pressure to violate state law may come within the definition and still not be an offense.
I
So-
understand that, but
You don't
Yes.
have it here, because here you've got consumption.
how do you interpret that phrase? In the
I interpret
statute?
that you could have it. For example, if I pressured someone to get in an automobile and drive drunk, that would be a problem. But when I have consumption, when I'm alleging injury from ingestion of alcohol, I've got a statute that says consumption, and that's the statute that applies. Forced is required. So if you're going to allege that the danger or the risk or the harm is the fact, and they specifically allege it, that people blacked out and all of those types of harms, which comes from ingestion of alcohol, then that is consumption. It's square on, and as strict constructionists, and not only we have strict constructionists, we have the rule of lenity that has to control here. So you're stuck, not stuck, it's a fact. And we're on notice of that fact because that's what the brothers, that's what the counsel and defendant said. Don't force anybody. That's what they're on notice of under the law, because that's what's applied. Don't enforce anybody to drink. That's admitted in the submissions. So there's no issue here. We don't have a situation where the more generalized concept, and you can have in the statute two different provisions, one of which is criminal, one of which is criminal, but the more general doesn't control where the specific applies. So the specific applies here, and yes, it must consistently control whether it caused an injury or created a risk of injury. Both are improperly charged here. There's no element. It may be that we want to control somehow drinking on campus or people involved. By the way, this goes to students, not to any other persons. It only applies to hazing, the act. So if we want that, and if we want that, then pass a statute that says that. But when you pass a statute and you say hazing is consumption of alcohol that is forced, and you're alleging my ingestion is the problem, that's consumption.
What do you think
That's what's
including
applied.
but not limited to means?
It clearly doesn't matter because it's required. It's a core prohibition of the statute. It's made clear that that's what's involved. So you can't have something more generalized when you have a specific provision in the law.
But what does but not limited to mean?
Well, it means that it could be other things because you don't have to have one of those specific ones.
Right.
But if you have one of those specific ones, Martin makes clear, the rules of construction make clear, the rule of leniency makes clear that you apply that specific prohibition under the law. Your Honor, I know you're grappling with it. I understand that you understand this conduct may not be meritorious. It may be
And I
not
just thought,
praiseworthy,
in talking
but
about
it's not
lenity, you'd
criminal.
only go to lenity if there's an ambiguity. And
That's
here,
right.
I'm just not seeing any ambiguity in the
I
statute.
agree. Your Honor, I think
There's-
there is no agreement.
There's
No
either you
ambiguity.
pressure or coerce someone into violating state or federal law. That's one way to violate the statute. Another way to violate the statute is to force someone to consume or other brutality.
You've got the specific one, the only one that clearly
Well, they
applies
address two
to the
different
Martin.
things.
No,
You
sir.
can force somebody to consume who's overage, 22, 30, 40,
Yes?
50, I guess if they're a student.
You're saying it's a crime?
But the violation of law has to do with underage drinking. Underage drinking is prohibited by law.
It's not, I think it's possession of the bottle that they were alleging, that you possess the bottle is what is alleged. That, again, that's another problem because it's not the direct cause. The direct cause is ingestion. And when you have a construct, Your Honor, it's a matter of applying the statute as it's written, which this court has pronounced is what we do, and that's what's there. So you do have an ambiguity
the
because you're
problem
trying to
with-
apply two
with-
different things.
With this is that the statute says pressuring or coercing the student into violating state law. That's
the general.
the black and white. That's what it
That's
says.
a more generalized provision. You got two problems. That's the more generalized. You go to the specific one has to control. There is no other more
So
specific
your
one than
argument is
consumption.
that and all three of you essentially made the same argument, that pressuring to violate state law can only be interpreted to refer to something other than alcohol consumption. That has to be your argument.
I think you have to look at the risk of harm, Your Honor. I think it could be in the situation. You could pressure someone to violate state law involving alcohol, as I gave you the example of
Right.
drinking and driving. That would, pressure me to get in the car and drive while I'm drunk, that's a problem. But pressuring me to ingest alcohol is not enough or encouraging, as it said, that's not enough. You have to force me under the statute if you're going to complain that the hazing is the harm, the risk of harm, or the harm itself is ingestion, is coming from the ingestion of alcohol, which is what we've got here. There's no question about that. They've alleged that very clearly. The bill in particular said that many of the underage pleasures drank to the point of intoxication, vomiting, blacking out, and death. Of course, many didn't drink. Many didn't drink at all, or many drank in moderation. So that's the problem. If you choose to do that, if you choose to go it, that's not forced. And that's the problem. So I would rest on the fact that it's forced. I ask the court to apply all the rules here that control. When the legislature writes the statute, we have to follow it. And the people are on notice. You got a new statute, and you have to interpret it that way, because that is the way we understood it as it was proper, because the record is clear that we understood. Don't force anyone to drink. Thank you, Your Honors. I appreciate your time.
Thank you. Now, are you going to make your argument on the cross appeal here also?
I guess I'll go ahead and do that because they're going to make an argument again, I think, after me. So I'll start with, I mean, a lot of what they're saying is something that I kind of already addressed before.
Well, let me ask you what one of the lawyers said, referring to the statement of particular saying encouraged. What do you say that you didn't adequately allege pressure?
Well, I think that part of it is the principle theory, and when you're using encourage, they're talking about that in the context of the principle theory. The pressure goes to, and you kind of brought this up a little bit, I want to give you a little bit of the timeline. Now, obviously, everything that happened would be inextricably intertwined in terms with what the brothers or executive council was doing with the pledges, but on Wednesday night, there was this reveal ritual. And it went into like about 3:30 in the morning. So I guess you could kind of say Wednesday night, Thursday. When these pledges arrived there, this is just right before because the actual party was Thursday night. They show up, and as you indicated, they were blindfolded. The brothers simulated paddling, making them think they were going to be paddled. They acted like they were going to be kicked out of the fraternity.
I mean, undoubtedly there was hazing in the dictionary sense,
Well-
but the statutory, the criminal hazing, none of those activities you describe until the drinking arises amount to criminal hazing, right?
No, this goes to the pressure, and even the trial court acknowledges this when you read the hearing. When they're talking about what the pressure isn't just the big brothers giving them the bottle. It's the process of what they learn. They have to be compliant with what the brothers or the executive council wants them to do if they want to be in this fraternity or they want to have the advantages, the networking, the parties, the getting
So the
through the
reveal
letters.
was Wednesday night into Thursday morning.
Right. And
that's
so it's
when-
really the same day.
And so that's when the paddling, and they're told they were not admitted into the fraternity. Then they're told, hallelujah, you're in the fraternity. And then, so tell me precisely what the allegation is as to Thursday night after these Wednesday night, Thursday AM events.
Right. And so the state's position is that not only that the pressure aspect is not just the having the party and being told about the tradition and the expectations giving the bottle, but the fact that they know that they have to comply with these brothers' wishes, and that if they don't, certain things will happen or won't happen, and that they wouldn't feel like they could say no. The state even in the record has, and it's discussed a little bit at the hearing, an expert that explains why even if somebody were to say right at the end, oh, by the way, we're not forcing you, that wouldn't change the dynamic because the brothers have done things all along to make the pledges feel like they have to be compliant.
The giving of the bottle to people underage is pressure?
Yes, well, that's part of it. I mean, it's sort of like the state attorney said.
Even if there's no statement, obviously if there's, you must finish this, that would be forced.
Right.
But here, little brother, I brought you a bottle.
Right.
That's pressure.
Well, that's part of it, but it's not the whole picture. Everything that was going on during the pledge process and right before is the pressure.
But doesn't that, all those pressure things that you allege, don't those apply to any kind of student organization that's allowed to limit their members?
Well, no, I mean, I don't think that every single fraternity or sorority engages in this type of hazing.
Well, hopefully they don't.
Yeah, I mean, no, I don't think that exists everywhere. But what I'm saying is, yes, we are saying that. But them watching people getting sanctioned or rewarded or being balled from the fraternity affects their perception of what they think they can say no to.
So is it your argument then that that's a jury question?
Yes, absolutely. And so I felt like, go ahead.
You go ahead.
I felt like the defense was saying, that this was unrelated, that it was just this one particular incident, but the whole pledging process is inextricably intertwined, especially the events that
All
happened.
right, let's talk about the statutory construction argument that they rely on, which is by specifying forced drinking, you can't interpret pressure to violate state law to include voluntary, to include possession of ingestion of alcohol by a minor. It's specifically the example of, well, it could encompass telling a pledge to drive while intoxicated, but it cannot encompass simply handing a pledge a bottle and saying, we expect you to drink this bottle, because the legislature said forced.
No, and this I kind of explained before, and I think Judge Osterhaus kind of reiterated this, is that the statute, I mean, why bother having pressuring or coercion if everything has to be forced? I don't even think they were saying drinking had to be forced. They were giving an example of brutality. If they wanted to limit it, they could have said so, and they wouldn't have implemented a statute that says includes but is not limited to. I mean, there's no way that the legislature could envision every single hazing circumstance, and which I imagine is why they have that wording in there. But that seemed to just be an example of brutality, and I don't see how that they can argue that, and I agree also what you said earlier, that they seem to be separate things. How you ascertain from looking at that statute that means that it has to be forced consumption. It seemed as though they were just giving an example of brutality of a physical nature. I don't see that at all.
Is there an issue here because this wasn't at bottom, this was an alcohol ingestion problem, and so that might fall under the brutality prong of this statute, whereas what's prohibited by the statute is possession. It's not
Right.
ingestion, it's possession.
Well,
Is there a distinction there between possession and ingestion that matters for purposes of reading this statute?
I don't think so. And first of all, they're giving them the bottle to possess, and when you're drinking, you're possessing it in your mouth. And then I also argued that I think that because it doesn't have to be forced consumption, I think that even if they had pressured someone to drink like this in excess, even over the legal age, that this would be hazing. But no, I did not see that as being a meaningful. Basically, their entire argument hinges on this has to be forced. And I just don't see that especially when they include the includes but is not limited to. That's not something that the legislature does when they want something to be limited to something. I mean, absolutely not at all. In terms
But that's dicey, right? Because that gets us into lenity and, well, what is prohibited by this statute? If we're going to hinge the resolution here on includes but is not limited to, and this is sort of out there in the penumbras of this statute or something.
as applied to these defendants, I mean, first of all, we already have a law that underage people aren't supposed to drink or possess alcohol. And I mean, a reasonable person would be on notice of this conduct. I mean, we know they knew. I mean, that's why they had this party off campus and had everybody go on Ubers and stuff like that. This pledge class was such a problem that they had to, implement a liquor ban. I mean, they knew the problems associated with this. In fact, I mean, this isn't really relevant, but there's a discussion a lot about, hey, they weren't bad guys below. They stopped someone from driving drunk. When you look at all the statements, it seems like they were more concerned not really with the safety of the pledges or the members, but with being embarrassed or being seen publicly. That's how I would describe it. I didn't see them as that mitigating things so that people weren't hurt, but mitigating their exposure. That's how I would describe it. I also need to address the defense's appeal. I think that it may not have been artfully drafted, but in the initial information, the state alleges hazing upon Andrew Coffey or any other member or prospective member of the fraternity. It then cites to the felony language the hazing resulted in serious bodily injury or death of Andrew Coffey, and then it cites to the misdemeanor statute. It wasn't just the citation to the misdemeanor statute that I thought put on notice that they were looking to charge them with both. It's also the any other member or prospective member. I mean, I admit I came into this case later. I opened this up, I look at the statute. The first thing I think, because I didn't know what the statute was or the subsection is, well, I know nobody else died or got hurt in this, and the state's alleging any other member or prospective member. And then I'm like, I wonder what this subsection is. And I look it up, and it's the misdemeanor. It took me all of about 3 minutes. And so everything is alleged in this initial information, which is clearly within the 90 days. So I don't think that we have a problem there.
To
Furthermore,
go back to the pressure argument, I'm sorry.
Oh, it's okay.
So the trial court's order you don't read as saying, I'm throwing this out because there was no pressure.
no.
The trial court's ruling was based on it wasn't forced, essentially.
I felt like it was based on I admit his order's a little confusing, but I felt like, and if you look at my reply brief, I copy and paste the whole order, that he's really finding the victim, to be an intervening cause. If you think about it, the only way that it can be these actions okay for a misdemeanor and not for a felony is because the misdemeanor has risk of. See, the victim wouldn't be an intervening agent in causing a substantial risk. He's only an intervening agent in his death by deciding to drink. And so otherwise, I just don't see any other way that you can find these actions sufficient for one and not the other. And then his own language, he might as well have written, I know the legislature said consent is not a defense, but I'm just not going to follow that. He didn't write it quite that clearly, but he might as well have. He says this is difficult to apply. And he even wrote something along the lines of, even if they did create a situation that, his decision to drink. I wrote this in what I really feel like he did is he pardoned the defendants. Really. That's what he did. You talk about a jury pardon. This was a judicial pardon. But there's no other explanation. It's very strange. It reads like, oh, he's dismissing this felony, and then you get to the misdemeanor, and he puts everything in there about why it's hazing, and it just doesn't make sense. And his language about basically calling the victim an intervening cause is the only explanation. I cannot even think of another explanation for that.
Well, I can see in terms of the forced consumption that when you're talking about forced has meaning, and if there's consent, well, what do you do with that? Those are sort of two sides of a coin, perhaps, forced versus I consent. Was he forced or did he consent? And those you don't necessarily check both boxes.
Yeah. Well, the thing about it is, if someone forced someone, especially of a physical nature, like held him down, you actually wouldn't need a hazing statute for that. If these guys had held him down and forced him to drink, this would be manslaughter at minimum. The reason, and it's indicated, this is in the record, the legislative history, the reason that we have this hazing statute and consent is not a defense is it was problematic for the state to prosecute these individuals because oftentimes they consented to it. That's why we have this, and that's why consent is not a defense. So if you have a judge saying, oh, well, the victim's an intervening cause, or he didn't actually use that word, but essentially said that, then how are we ever going to prosecute hazing? In fact, technically, Chad Meredith, he decided to drink and decided to swim. I don't think there was any indication that they forced him in the water and made him, but yet he's the reason for that act. The legislature worded it this way to get around this, and the trial judge's ruling completely eviscerates the statute. He makes it so unless somebody really was forcing somebody, like holding them down or something like that, then the person's agreement to do it would pretty much prevent us from prosecuting under the hazing statute. So quickly back to the misdemeanor.
Yeah, you have plenty of time.
Back to the misdemeanor. after indicating that I think that they were on notice, they talk about cases from other districts saying that prejudice doesn't matter, but this court's decision in Holland indicates that prejudice is the central inquiry. And obviously they weren't prejudiced here, especially in regard to the, any other member or prospective members. I mean, there's rosters with these people's names on it. In fact, these defendants would know who those people were probably better than the state would. They were on notice of that. Also, the trial court ruled that this was, in regard to the other people in the fraternity, that this wouldn't exactly be the same conduct, because even though the defendants agreed to these things, that it would be a different circumstance for each one. Also, I agree with the trial court statement that if you, if you have hazing and it results in death or serious bodily harm, how is there not a risk of that? And so you would just be on notice. Does this court have any further questions about either of the issues?
No, I guess you're entitled to rebuttal on the cross appeal, and then they've requested serve rebuttal, how that all works out with us much time, but I'm going to assume you're waiving your time on any further arguments on the cross appeal.
Yes, Your Honor.
Thank you.
May it please the court. Obviously, my SIR rebuttal is limited to the misdemeanor cross appeal, but I think the issues we're discussing affect both the misdemeanor and the felony, so I'll jump into
Well,
them.
would you agree with the state that something's got to be wrong?
Yes.
Either that he was wrong in granting the felony, or he was wrong in denying the misdemeanor?
Yes, I agree with that. And so I think, I'm not going to continue to argue the statutory construction argument. I think we've made that point clear. The court understands our argument regarding forced consumption. The court is asking a lot of questions about the general provision involving pressuring or coercing. And Judge Thomas, you followed up on my point that I said earlier, and I respectfully disagree with the state. You asked, what about the fact that the statement of particulars only mentions encouraged? And her response was, well, that goes to the principal theory. Respectfully, it does not go to the principal theory. The principal theory is you aid or assist someone else who engages in an act of hazing. The state still has to point to an act of hazing.
But isn't that the act where the other defendant who later pleaded told him, we expect pledges to finish the family bottle?
That's the key. So let's back up and say, how did this case start? There's a number of ways that the state can prove hazing.
Before you go on, so essentially...
Well, I disagree, obviously, with what you said.
Well, essentially,
We expect. That wasn't said. Those aren't any of the facts. That's never been alleged.
Well, what did he say to him?
We do have a document that tells us what's being charged in this case.
Now, what did the person say?
All we know is the charging document.
Hold on.
Or encouraged.
To the deceased.
Encouraged. Mm-hmm. Well, that's the answer, Your Honor. Because
So your argument is, aside from the statutory construction, assuming we disagree with you there.
Correct.
That there's no evidence of pressure.
it's not even that there's evidence. I think so you're getting into evidence, and I understand your whole C4 question. I don't think we're at the point of is there evidence.
I understand motion to dismiss as a matter of law.
Correct.
Your argument is that there's no evidence of pressure, therefore there's a missing element.
Can I rephrase it? I want to rephrase this. I want to back up. The question that was asked, Mr. Tannenbaum said it. What act of hazing did our clients engage in? The judge held a hearing on this. This was argued extensively at the April 18th hearing. The judge agreed with the defendants and said, State, I am telling you, there's several things under this statute you could allege. You must allege one of them in order for there to be an act of hazing. They came back with this document. It would have been very easy for them to track the language of the statute and simply say, oh, they pressured or coerced underage pledges to drink. You don't find that language anywhere in here. All you find is encouraged to illegally drink. Encouraged. Encouraged does not rise to the level of pressure or coercion that would amount to hazing. So Judge Fitzpatrick said you still have not alleged a single act of hazing that would subject them to face these criminal charges, and I'm dismissing the information because you can't point to an act of hazing in this case. They could have come back and said, if this document had said we pressured or coerced, we'd still be having the statutory construction argument. But if we're wrong on that, you can
That's
point
what
to
the
that.
information says, right?
But this supersedes the information. You know that. And that's when the court orders the state to submit a bill of particulars, this replaces the information, and the allegations in this document control the case forevermore. This is what the defendants get to defend against. So now they are defending against an assertion that actives encouraged pledges to drink. Encouraging is not a crime under this statute. Pressuring or coercing is. They haven't alleged an act of hazing, and he properly granted the motion to dismiss.
And
Thank
therefore,
you.
the misdemeanor should have been dismissed also.
And not for all the yes, and because the speedy trial was clearly violated, which we haven't really addressed in this oral argument. Thank you.
Well, thank you both for your arguments. We'll be in recess.
All rise.